counsel has not done anything to address these requests.
You're making excuses. My point is, I'm just really not very impressed with this dog ate my homework defense. Where are we with this discovery, Mr. Stevens?
Good morning, Your Honor. Scott Stevens for the plaintiff. We still do not have the responses to second interrogatories and requests for production of documents. We filed a motion for discovery sanctions, which is unopposed on November the 17th of last year. And we also filed a motion for summary judgment on counterclaim relating to the admissions that are in the record based on the failure to file responses to those, which is also an unopposed motion. And so we've set forth a prima facie case for summary judgment on the counterclaim. The defendant's counterclaim alleges fraud, requests punitive damages, and attorney's fees. And they've admitted, based on these 6 requests for admissions, that we're entitled to judgment on the counterclaim. Admission number 1, they've admitted that they failed to state a claim upon which relief can be granted. Admission 2, they admit they're entitled to no relief whatsoever on the counterclaim.
What is this? A advertising of sorts? A contract?
Yes, it's a marketing contract.
Just say that, Ms. Pollard.
Yes.
Okay. Go ahead, Mr. Stevens.
It's a marketing contract to promote the business of the defendant online. And so it's a complaint on a contract.
So is it like in the nature of a collections case?
Yes. So it's our position.
What is the amount you seek in the complaint?
$84,500 plus interest and attorney's fees. So they've admitted that they failed to mitigate any of their damages claimed in the counterclaim. They've admitted that they failed to plead fraud with particularity. And they've admitted, which is in fact true, that this is a contract case. And they've admitted they're not entitled to punitive damages in the contract case. So under OCGA 91136, these admissions are considered to be solemn admissions in judicio in this case. And I've cited some case law in my brief, including...
I got all that, Mr. Stevens.
Yes, sir.
What I don't think I have is an actual set of your requests. Did you file any of that?
Yes. The requests for admissions are attached as Exhibit A to the motion for summary judgment. And then as Exhibit B is attached the Rule 5.2 certificate. These are filed in, the 5.2 was filed as Exhibit B with the motion for summary judgment on counterclaim. And that was filed on January 3rd, 2024. There's been
I have it. Thank you.
Yes, sir.
All right, Ms. Pollard?
Yes, Your Honor.
Or Ms. Solomon, what say the defense?
Your Honor, this is actually a case that I have been the lead on this case, and actually Ms. Solomon is here because I was supposed to be in in-person criminal court, which apparently they've completely removed off the calendar and only told me this morning. But with respect to this case, Your Honor, at no point in time did we receive the second request for admissions. The court will, or what we're positing to the court is that when we first received the petitioners or the plaintiffs' first request for discovery, they were mailed to our office. Our then paralegal emailed opposing counsel's office and informed him that we request that all of these documents to be sent to us via email, and not only for it to be sent to us via email, but that all staff in the office be copied. And that would really just me, Attorney Solomon, and the paralegal at the time.
Well, that's not the rule of discovery, counsel.
Oh, no, I understand. But what I'm further, or at least I'm establishing where we previously requested that they send these things to us via email, because we have never received a physical copy or the mailed copy of the second request for admissions that Attorney Stevens is claiming.
So your position or your statement to the court today is that you have no copies of this second request for production, second interrogatories and request for production of documents.
And when we reviewed,
is that correct? Is that what you're telling me?
That's correct, Your Honor.
All right.
We do.
So let me finish, please.
Okay.
So having not received any of that, you were served with the motion for sanction to strike the answer in the counterclaim that was filed on November the 17th, 2023. Did you?
Give me one moment, because I know we looked into, it was the motion for the motion to dismiss the counterclaim. And I'm going to look up the, if Your Honor, give me one moment.
The motion for sanction was filed on November 17, 2003, and the basis is that your failure to answer the second interrogatories and request for production of documents that was filed or served on the defendant, as at least according to the motion, on September 20th, 2023. So you're telling me you never got anything from the September 2nd, 2023 documents, and I assume you did get the motion for sanction that was filed on the 17th. Did you?
And I'm looking, Your Honor, I'm looking, even when I look online, I see November 28th is a motion for, or this is a jury demand. I see we received a filing for a standing order, but when we look for Odyssey e-file, I don't even see this particular motion.
You don't see a motion for sanction on Odyssey?
Not that,
November 17th?
Not that was sent to us, Your Honor. November 17th, no.
I'm sorry. If it's e-file, it was served on you.
I am looking at my email, Your Honor, and I don't see anywhere where you're saying November 17th, where there is a motion that was sent to us. We have November.
All right, let me ask you this then. You are well aware of why we're here today, yes?
Yes, we are now, yes.
Have you before today, ever even pick up the phone, call Mr. Stevens' office and said, hey, we don't have either the sanction I don't see online, nor do I have your second request for interrogatories or request for the documents?
Not at this time, Your Honor, because it wasn't until we received the email for the Zoom information that it had us.
And when was that? When did you receive the Zoom information?
The email for the Zoom, Your Honor, came in, I believe this was Tuesday.
Tuesday. Did you make a call between Tuesday and today?
I did not make a call between Tuesday and today, Your Honor, as
okay.
I've only arrived back into town, Your Honor, midnight last night, or this morning, I should say.
Yeah, Solomon works with you, does she not?
She's not.
You have a paralegal in the office that triage all this. My point is, I'm just really not very impressed with this dog game of homework defense.
Your Honor, at this time, we don't have a paralegal, which is why I said the paralegal at the time.
The Rule 9-SI was filed on
March 14th.
For show cause for this was filed in Odyssey and served on you on March the 14th, not Tuesday. Are you telling me you don't have this in your e-file system? You don't have the Rule 9-SI on the sanction motion and summary judgment motion, ma'am?
The Rule 9-SI is the only thing that has come into our office, Your Honor.
Have you made any effort once you've gotten the Rule 9-SI to find out what this is even all about?
We had not reached out to
no.
Your Honor. However, when it comes to
counsel, you're making excuses.
Well, at this point, Your Honor, we would ask if we would at least be given the opportunity to respond to the request for admissions, seeing as the request for admissions are simply requesting that the counterclaim be dismissed, and it's not. We do not believe that being allowed to move forward and respond to the request for admissions is going to cause big harm as it pertains to this case, Your Honor. And again,
do you think you should?
Pardon?
Go ahead, finish.
I was going to say, I do not make excuses as it pertains to reaching out to Attorney Stevens once that Rule 9-SI came in, but also there's the fact that at the end of the day, if discovery is sent, and I believe the court can even see I believe that January notice, which was emailed to us, only emailed. We actually don't have statutory electronic service on that. It was emailed to Attorney Solomon during her leave. It was at this point when I was going back over the documents, I don't even see where we received the Odyssey e-filing for this motion. And I believe Your Honor is able to view the service contacts as it pertains to when motions are filed. Even the 5.2 for the request for admissions that is stamped we didn't receive that stamped copy. It was a 5.2 that was filed, and
Ms.
that
Pollard, Ms. Pollard, do you, what I'm hearing from you is that none of the e-file documents are served upon you via email in accordance with the rules. That's what you're telling me. That
not
it's
none.
not, excuse me, please, let me finish. It is not Mr. Stevens that hasn't served you, that you are simply not receiving documents from the court in the Odyssey system, both in terms of documents filed, well, probably not the discovery because he's going to send those to you, but at least the motion for sanction, the rude and eyesight, and all of that. Nobody has gotten nothing from the court. Is that what you're telling me?
I was thinking, I do not see the motion for sanctions that Your Honor is referencing with the November. And you're correct in that we did not receive the request for admissions nor the January filing. We have other communications with Attorney Stevens when we had the previous issues with respect to discovery, where we're communicating back and forth. And when there were issues that arose, there was an email.
I'm going to give you 10 days to file a response.
The responses to the request for admissions, Your Honor? Or is it responses for the request?
I want you to answer those discovery, Mr. Stevens. When we get off this call, you send her a copy in email or an email attachment, your request for production, your request for admission. Just send her a copy. Ms. Pollard, you have 10 days from today to fully and completely answer both the requests and the discovery and produce all the documents required. No objection is allowed. Answer.
Yes, sir.
Well, Your Honor, relating to the interrogatories and the request for production of documents, I had a phone call with opposing counsel, according to my notes in my file, on December the 1st, 2023. And we discussed getting the case continued, and we discussed dealing with the discovery issues then. The motion for discovery sanctions was served. There's been no response to that, but even more importantly, the admissions are in the record. Opposing counsel has not done anything to address these requests for admissions, which are admitted. And so as to those, it's our position under Georgia law that the plaintiff is entitled to summary judgment on the counterclaim. And
I'll take that under consideration, Mr. Stevens. If you will document for me your efforts, okay? Just put it in writing. Just tell me what date you talked to her and so on and so forth.
I'll update my affidavit on the motion for discovery sanctions, Your Honor, to show that on December 1, that I engaged essentially in a good faith conference with opposing counsel to get responses to the interrogatories and the request for production. They still, all these months later, have never been submitted. The admissions are already in the record as solemn admissions in judicio, entitling us to summary judgment.
I'm not so sure some of those you're entitled to admissions on, but excuse me, please.
If Your Honor looks at the case I cited, this
Mr. Stevens,
Bass versus Fulton County case, I think the court will see that we are entitled to propound requests for admission, even on legal issues.
Mr. Stevens?
Yes, sir.
Stop. Just stop. So, on this breach of contract, have you all talked about resolution?
Not really, Your Honor. Our phone call on December the 1st was mainly about the court calendar and dealing with the outstanding discovery issues in the case.
All right, well, I'm dealing with two things. I'm dealing with a summary judgment motion and a sanction motion to strike the counterclaim. That does not change the main case, the collection case for this breach of contract. There's this set of interrogatories that ask for all this information. And so, Ms. Pollard, you have 10 days to answer those in full.
Yes, Your Honor.
Okay? And you will file a motion if I'm gonna, never mind. I'm gonna give you a lifeline to answer those omissions, or at least file a motion to tell me why those omissions should be withdrawn. 10 days.
Yes, Your
Okay.
Honor. And
Not, listen to
if
me.
I may,
Not only the rule says you have to ask me now to withdraw those omissions. So file your motion. You got 10 days to do it. You also have 10 days to answer this discovery in full. This is your lifeline. Do you understand?
yes, Your Honor, I do understand.
All right. I will see you all next month.
May I please have a good email address, Ms. Pollard, to send that discovery to you?
It would be the same ones we've communicated previously. That's Vicky, Vickie, at thesolomonfirm.com. And
Good.
Solomon is spelled Solomon. And we've also previously mentioned attaching Ms. Solomon, so that's going to be Tricia, Tricia, at thesolomonfirm.com.
Very good. Now, I would seriously urge the two of you to sit down to talk about resolution of this matter and not grind paperwork. Make an effort. If there's merit to the claim, solve the problem.
Yes.
Yep.
I'll put this over to the next month's motion. There will be, what day is it?
May 9th,
May 9th at
9 a.m.
9 a.m. I will send you a newsroom link. There will be no other Rule 9 sign and so on. Just get it done, please.
Will do, Your Honor. Thank you.
All
Thank
right.
you, Your Honor.
Thank
Take
you.
care.